Welcome to this panel on European champions and how to make companies competitive on the world stage. I'm Francesca Micheletti. I'm a senior competition correspondent for Politico. And, well, we're going to talk about this exciting topic. I guess it's about trying to get our own Google. I was thinking as I was hearing the Google speaker about how to get companies that are big enough to compete on the world stage. So joining me here, I have Anthony Whelan, Deputy Director General for State Aid at DG Competition, Isabel Iglesias from Business Europe, Agustin Reina from Consumer Group BEOC. So, European champions, it's not a new world in the EU bubble. I'd say the debate is at least as old as 2019 when Siemens and Alstom train makers wanted to get together and their dream was shattered by DG Competition because the concentration just was going to be too high and it was going to hamper other players in Europe. So the debate has moved on since then. We're in a new phase. Competitiveness has become the imperative. And the Commission has been listening. We hear statements on European champions. We have heard President Ursula von der Leyen. We have heard Emmanuel Macron speaking about European champions at the recent summit in Aldenwiesen. The word is not going away. So what is the Commission doing? One very concrete piece of legislation, or rather guidelines, that the Commission is working on are the merger guidelines. And this is why I want to kick off the conversation with Anthony, who is very close to the kitchen of the guidelines, and to give us a bit of an update. So when are the guidelines going to land? When are we going to see them? And what is in them?
Thanks, Francesca. Well, I'm close to the kitchen, but not in it, because it's not state aid, but I'll happily fly the flag this morning. So the President herself announced not so long ago that she hoped to see them come out in April in draft. This is a very inclusive process, so people will get to see them in draft before they get to see them in real. And that is the timeline that we are working to. A month has, give or take, 30 days in it, so I'm making no further prediction than that. But then the idea is to take input on the specific text. We've taken already a huge amount of input in various settings from stakeholders on the general questions that this topic raises. But people will now get to see concrete text, the real balances that we seek to draw as we must, between the harms that certain mergers can bring and the benefits that they can bring. What we're very keen to show is that this is an even-handed balance for all parts of the merger assessment. The good and the bad, let us say, a similar standard of proof and of assessment will be applied, and the overall objective will remain the same, to identify the normally, give or take, 96 or 99% of mergers that are relatively unproblematic, with or without remedies, and the less than 1% that give rise to insoluble problems. That remains the benchmark, but we are, of course, seeking the solutions to the problems wherever the parties can bring them.
Thank you. I will get back to you on the guidelines because we want to know more. But first I wanted to give the floor to Isabel, who represents here the industry, what the industry is expecting from these guidelines and from the Commission.
That's a very wide question, and it's thanks, first of all, for inviting Business Europe to be in this roundtable today. I would like to go back to the title of the session, because I really think that putting the discussion in terms of creating European champions goes a bit beyond, or kind of distracts the conversation from all the other homework that the institutions, the businesses, that member states needs to do to really relaunch European competitiveness. Because I think that here we are not talking about creating giants. That's not probably in many ways the European model, but rather about ensuring that the practice of the Commission and that the general view on mergers does not block reasonable measures that may kind of lead to further innovation, investments in resilience and sustainability, and other kinds of gains. So the debate for us is more or less there, I would say, and in getting clarity from the Commission in the guidelines in terms of how to better assess innovation gains, infrastructure gains, etc. in the guidelines, so getting some more flexibility in the assessment so that all of those benefits can be better taken into account, while at the same time, of course, not losing in legal certainty, which is, of course, another very important part of the discussion for businesses.
Thank you. Agustin, so consumers have taken perhaps one of the strongest views on merger control and essentially supporting the traditional, well, the conservative view that has been enforced up to now. Is there any opening that you have towards the process that is currently going on?
I will not say that we have taken a conservative view. We are kind of the purist saying like, continue doing what you're doing. Of course, markets evolve, markets become more complex, and so the enforcement becomes more complex. The question here is about what are the aims of merger control. And the purpose of merger control is the most important ex-ante tool that we have to make sure the markets remain competitive, that companies can scale up, but as a result of a competitive environment, not of monopolistic behaviors. And when we look, of course, at how merger control has been approached, the European Commission, also the member states, have been innovating quite a lot in the way that they have been approaching it. And this is because we have a system in place which is broad enough. When we talk about, for example, consumer welfare, the discussion about consumer welfare in Europe is different to other places of the world, particularly in the US. Here, we don't only look at prices. We also look at quality of services, we look at choice, we look at many other non-price effects that are important to make sure that markets deliver to consumers. I think here what is the fine line is about what is the weight that we're going to give to all these different parameters. And of course, when we look, for example, at pricing, pricing is one of the most measurable elements that we have. But if we think about, for example, future investments, that's extremely difficult to police, first of all, and whether a company will commit to make certain investment or even to innovate, because markets evolve rapidly, and obviously the circumstances might change. And also, what I think it's important also to bear in mind is that there is no evidence of over-enforcement here. On the contrary, the European Commission clears the wide majority of mergers, and only those where effectively there is a risk for competition and therefore for consumers, the Commission have taken a more strict approach, either prohibiting it, which is really the tiny minority, or seeking conditions from the merging parties. So it's also a matter of putting things into context.
Yes, you have raised a very interesting point, which is about future investment. So one of the debates in the guidelines, if we understand it correctly, is about allowing mergers when companies promise that this will lead them to better investment and more innovation. Anthony, what is the Commission's view on this so far?
Well, just taking up where Agustin left it, in merger control, we look at all the parameters, not just the price, but the investments, the innovation, these more dynamic elements, the quality. And we look at them on both sides of the accounts ledger. And you can have mergers that raise propensity to invest, to innovate, and so on. And you can have mergers, typically rather rare, but these are the ones people focus on, which reduce that propensity. For us, it always comes back to two key questions, and promise is not one of them. It's about ability and incentives. The best pro-competitive merger is not one where the parties promise to innovate, but where we see they acquire an improved ability and incentive to innovate, to invest, to develop new products, and so on. Because those are the ones that don't need us behind them to say, look, you said you would do it. They will be doing it because it is integral to the economic logic of the deal. So there's a lot more focus on that interplay between the different forces at work in the market than there is on remedies, which is, by the way, not strictly speaking a subject of this, because there's a separate remedies notice.
And do the new guidelines provide more leeway to companies to argue for the investment benefits of their deals?
I mean, what we try to do with the theory of harm or the theory of benefit, the two sides of the equation, is to make clear that they shouldn't be done in sequence, as has been, I think, typically been seen as the case with efficiencies up to now, or benefits. Really, we should be looking at all aspects of the dynamics that a merger will create from the beginning. If the parties think that it will create a strong innovation or investment dynamic, that should be on the table with their best evidence from the beginning. Rather than the thing which I think prevailed in the past of saying, well, if we raise efficiencies, it suggests that we think there's a problem, and we're saying there's no problem, and da-da-da-da. So really it all needs to be in the mix from as early as possible, and we are planning to make that quite clear, along with the overall approach to balancing the positive and negative potential effects of the merger. Now, as Agustin said, it gets more difficult when you are looking at effects in different parameters. You have an investment propensity, but a possible short-term price effect, and that, of course, is something on which we cannot give hard answers, but we will hopefully make clear that everything is looked at in the round.
Yes, so if I understand it correctly, it's if you bring forward some efficiencies and some innovation benefits, it doesn't mean that your deal is going to be problematic. It's just good for the Commission to argue early on with the companies about it. Isabel, I have another question for you. As Agustin mentioned about the overwhelming majority of mergers being cleared, this is data that is often being talked about in conferences. But I feel that the business perspective is a bit different, because what they say is also, well, there's a lot of deals that you don't see, that are not even conceived. They don't leave the boardroom because of regulatory fears. Do you have anything?
Indeed. And thanks for putting this question, because I actually wanted to raise this comment. Indeed, the numbers, the statistic of actually mergers that were prohibited or that were withdrawn even last minute because of very stringent remedies is small. I mean, the big majority of mergers that are notified are passed, but when you talk to practitioners, be it economists, be it people from the industry, lawyers, they talk about the deterrence effect of not only the current guidelines, but rather of the very strict approach by the Commission on the study of the short-time price effects of mergers. It is very difficult for companies to argue the longer-term innovation, sustainability, or resilience gains, while it is very easy, so to say, to prove the short-term effects on prices in a way. And that's why, I mean, and in this, the business community is completely united, all sectors and all sizes, that what they need from the new guidelines is really clarity in the way that they can argue, that they can present these complementarities, these synergies, and longer time frames for the analysis, so that these gains that can actually really benefit the consumers and all the value chains from smaller to bigger companies are really taken into account in the assessment by DG Competition.
Thank you. And if we want to zoom in a bit on sectors, you spoke about the industry as a whole, but we have heard several voices that are louder than others. And I'm thinking of telecoms, first of all. Agustin, is there anything we can say on telecoms mergers? Like, why is it specifically important that merger rules are actually not relaxed?
I think first, what we need to acknowledge is that all the different sectors, they say we are unique, we're all different, but the effects of market concentrations are the same. Prices goes up, less incentive to innovate, so on and so forth. That's the basic economic theory. When it comes to telecoms, things are a bit more complex because we're talking about a liberalized market. So it's a market that we were coming from monopolies, where there was a conscious decision of the policymakers to say, we're going to open this market to competition, we're going to give it to the market, the states will do hands-off. But for that, because we're talking about an industry with very, very high entry barriers, we need to have these ex-ante rules in order to stimulate entrance and competition. And there is where the national regulatory bodies play an extremely important role. But at the same time, we have merger control side by side. And there is a question of how these two areas actually interact. And what we're seeing, for example, right now in Brussels, was a very heated debate on the two fronts. So we have on one side, when it comes to the regulatory framework for telecommunication services, where part of the industry is saying, no, we need to be softer on the ex-ante rules. And on the other side, we have, but we also need to make it easier for us to consolidate. But from the point of view of the consumer, the liberalization of the telecommunication market, through this ex-ante rule and through a strict merger control, has scenario across member states. It's true, we don't have a single market for telecommunication services, are national markets. But within these national markets, we have seen an appreciable level of competition that have emerged in this post-liberalization scenario. Now the question is, do we want to continue in this path, or we are going to change the tide and go for in-market consolidation, which is what some of the incumbents are asking for. But if we go for in-market consolidation, that would only lead to higher prices for consumers because it's all about capturing this consumer surplus. And you can only do it when you are in a monopoly or quasi-monopoly situation. And that is where we have to be extremely careful in this sector, because if you compare what have happened in the US, and it's a little bit of anecdotal evidence that I think all of us have encountered, but you had kids during COVID doing their homework in a McDonald's because they didn't have internet in their homes or because it was too expensive to afford it. This is something that didn't happen in Europe.
Yeah, we certainly wouldn't want our bills to be higher. Talking about sectors, Anthony, do you think a sector-by-sector approach is conceivable on merger control, or will it always stay sector agnostic?
I think it's even more than that. In reality, it's a transaction-by-transaction approach. Every transaction is looked at in a dedicated fashion. I mean, the simplified procedure ones, obviously, it's a quick look because there's nothing that sets off the alarm bells, and that 90%, I think it's around 90% of cases then go through very quickly. But when it raises some questions, it is really a tailored assessment, and it will be driven, certainly as regards the benefits, very much by what the parties bring to the Commission, because no one knows their business case better than themselves. They will be unlikely, perhaps, to raise the potential harms to us, so of course that's our job to do the check. But as long as both aspects are examined to the same standard of evidence, then I think that's a pretty fair outcome. Now, of course, going back to something Isabel said, different dimensions of a merger have a different type of evidence base. If we take the models that exist for things like price effects, we cannot unknow things that we know. So it's like you can't uninvent the nuclear bomb. That's maybe not the best analogy. So when there are available methodologies that determine the likely effects on one parameter, we should not deny ourselves the use of them. If other aspects are somewhat more dependent on specific evidence that the companies have to bring, well then let them bring it. But we will look at a telco in-market merger in the same way as, well, not in the same way, but with the same tools as we will look at an in-market merger of two major manufacturing companies in a 4-player market, assuming the telco one is a 4-player one. And then we look at the dynamics, which may be very different in the two markets in terms of speed of deployment of new products, the infrastructure element and the investment requirements that it brings, the effect of scale in terms of financing infrastructure as opposed to the effect of competitive pressure in terms of driving the deployment of that capital, no future case is determined by any one past case or cases.
Yeah, so telecoms are not going to get a special treatment, despite the comment, the en passant comment of Council President Antonio Costa, who spoke of a social contract in Alden Bees, a social contract on mergers. I wonder if anyone in the audience has an interpretation. I mean, we should ask him, but as he's not him. A social contract on mergers, by which we kind of allow mergers if they advance social goals.
What I wondered, who are part of that social contract? When we talk about social contract, is we as a community, as a society, we decide to agree how we're going to be ruled. But in this case, I don't think that consumers, or citizens actually would appreciate a social contract or a contract under the name, which leads to greater concentration and higher prices. So I think there is a matter of also analyzing a little bit what do we mean by that.
Yeah, definitely.
But again, if I may, I think that part of this social contract that was referred to by Costa also referred or could open reflections towards, as I was saying, the wider sustainability gains. That's another big claim that the businesses are making, that longer time frame sustainability gains are taken into account. And this, I think that it's very interesting to put on the table what the Dutch Competition Authority is putting into practice, which is analyzing the effects in the wider society, so like citizenship, and not only the consumers in the specific defined market where the merger takes place. So I think that that is something that the Commission will certainly be taking into account a bit, like the wider effects. And I think that that's something that, while keeping the legal certainty, needs to be taken into account in this review.
Yeah, well, thanks for opening the door to me on that one, Isabel. I mean, I will not try to interpret the European Council President's words, but I think we are approaching the new guidelines as not a deal, but to create a shared understanding of how we apply the merger regulation going forward. So with the learnings of give or take 20 years since the current test was introduced, a bit longer since the regulation itself. So part of it is an incremental learning, part of it is a response to much more recent developments, be it on the geopolitical front, on the climate front, on the international trade front. So part of that is about looking at collective benefits. So will the merger, because it gains access to an interesting supply source of something rare and critical, improve European economic resilience? Now there we need to look beyond the parties, of course. It's the economic resilience of our economy. So laying hands on something critical and rare and depriving other European firms of it by the same motion might not be looked at so positively. So it will always be contextual. But the thing to bear in mind is, ultimately we organize our work around markets. So collective benefits can be a very important gain through a merger, but it should not be a particular subset of customers who are paying, because in a sense that's robbing Peter to pay Paul. So we cannot completely shift the focus from specific customer groups organized in geographic and product markets as we know them.
Yeah, maybe on that as well. And of course that now we have an opportunity in the guidelines to modernize the guidelines and looking at sustainability elements as well. I think that is an important element of the conversation, as we have also with antitrust guidelines on this. But I think that we also need to be mindful of the fact that this should not be a way to go back to a total welfare debate when we consciously decided to move to a consumer welfare, to put the emphasis on the people that have been affected, in this case by an operation or by a practice. So it's about having an evolution, not a revolution of the way we are doing it. And also bearing in mind that in a world that is highly unstable and volatile, it's something that we have learned through competition policy, is that with stability, you can make actually much more progress. Look on the different fields, from digital to sustainability. The evolution of the case law and the approach of the European Commission is quite significant. So I think that here it's not about revolutionizing everything, but really taking it one step forward, but keeping a very clear north that we are doing this obviously for the European economy, but for the European citizens at the end of the day.
Yes, evolution rather than revolution is what the Commission likes in general. So there seems you're on the same page with the Commission. As we had close to wrapping up, I wanted to ask each of you, well, you to the key expectation on these merger guidelines. Well, the question for Anthony will be slightly different, but in a few words, what are you expecting from these merger guidelines? Isabel.
I start. Well, so as I was saying, this wider or more flexible approach to take into account other criteria in the assessment of the Commission, while, of course, I mean, the principle stays competition, contestability is a prerequisite for competitiveness. At the same time, I think also that we are in a framework in which it is all the more important that competition policy really interplays with all other industrial policy tools. And so that is something that we are looking with a lot of attention, the interplay in all the reviews that are ongoing in the world of competition, also everything which is happening on state aid. And let me say that in a way, as an observer, so to say, from the horizontal view of the Commission, of the competition policy instruments, we are somewhat surprised or amused to see how flexible the Commission is sometimes being or becoming in terms of state aid control, while they try to stay very, very, very strict in merger. It is a bit surprising how in the one side we are seeing an evolution in terms of flexibility, which is very, for some it's not a positive evolution, while remaining or seemingly remaining very strict in terms of merger control.
Do you want to quickly react to that, Anthony? Merger control, stiff, state aid, relaxed.
Yeah, I'm not sure I fully recognize the point, if I may say. And state aid, of course, is my daily bread, because if we look at either the present or the future merger guidelines, of course, I've seen the future ones and you haven't, they are framed in ways which are responsive to the facts as we find them in any given merger, and based, of course, on a clear legal test, as Agustin recalled, of consumer harm or of customer harm. In state aid, we have a slightly different objective. It is safeguarding the level playing field of competition between member states. So what we are trying to do there is to ensure that member states are able to invest in things that are regarded as being in the common good, in R&D, in rolling out renewables, in ensuring the transition of energy-intensive firms to the new clean economy, while avoiding excessive distortions. And sometimes that leads to things that are much more rigid than you will see in a merger guideline, like aid intensities of X or Y%, or extremely precise analysis of the funding gap for companies that are investing in IPCIs. So I'm not trying to build myself up now as the super nasty state aid regulator, but I don't think one is just a sea of flexibility and the other one a rock of rigidity.
Thank you. Agustin, very quick final expectation on the guidelines.
Yeah, I think that even beyond the guidelines, we need to have a clear understanding, what do we mean by an European champions? You know? And I think that here there are so many different interpretations. I think that what I would like to see, you know, is when we talk about European champions, these are companies that are scaling up in Europe as a result of competing on the merits. They are companies that comply with our rules, our standards, our values, and that they can get financing in Europe, you know, through our public capital markets. Now, that will be the fantastic, and like this, yes, we need many European champions, many European champions. We don't need monopolists. We need many European champions that fit these standards.
And on this positive note, the panel comes to an end. Thank you all for joining us. You will now have a 30-minute coffee break and then be back in the room for the next panel, which is about tearing down single market barriers with my colleague, Aude van den Hove. Thank you.